Welcome. Thank you for joining us today. We're really happy to see you here. And today we're going to be presenting on immigration judge perspectives on pro bono representation and best practices. My name is Laura Egan. I'm a managing attorney with CILA, the Children's Immigration Law Academy. And we welcome you to say hi in the chat. So please go ahead and click on it so it says to panelists and everyone. You can include your name, where you're located, your organization or firm, if you're affiliated, or if you're a pro bono attorney, you can include that. We're grateful that you're here with us today. So I'm going to provide some information about CILA. CILA is a project of the American Bar Association, and we are a legal resource center. We're a capacity building organization, and we don't think children should have to go to immigration court alone. And that's a really big reason why we are involved, why we're doing this work. So thank you again for being with us today as we talk about this important topic. And if you're not familiar with CILA, we want to go ahead and provide some information about us. We are a project of the American Bar Association's Commission on Immigration, and this slide covers the services that we provide. We provide technical assistance regarding case-specific questions relating to children and youth with immigration cases. So if you're working on a case and you have a question about the substantive law or how to work with a child, you can contact us for questions. And this is available to practitioners in Texas, as well as to the VERA network, or if you're a pro bono attorney with the organization within the VERA network nationally. We also offer 4 national working groups on asylum, special immigrant juvenile status, pro bono coordination, and working with detained youth, and 2 specific working groups on Houston SIJS and social services. And each of these groups meet on a quarterly basis. We provide these to have space for collaboration and community for practitioners. CILA also provides trainings and written resources, which we largely put on our website. And these are available for free and available to access easily. So we encourage you to check those out. We also host a platform featuring pro bono opportunities across the nation. And we provide resources related to pro bono assistance as well. We have a social work program that provides training and resources and answers technical assistance questions for practitioners in Texas. And at times when there's been increased presence at the border, when emergency shelters have opened, CILA has helped as needed. So that's just a little bit about our services. We encourage you to learn more on our website. And this is the CILA team. We are happy to say that we have grown this past year in 2022. So we grew from a team of 7 to 12. And this is everybody who you might see emails from. Here are our faces. So we encourage you to reach out to us at any time if you have any questions. And now I'll go over some, there we go, housekeeping matters that we want to cover for this webinar. This training is an hour-and-a-half long. And if you have questions, please use the Q&A function rather than the chat box. And you can find that at the bottom, typically, of your view. And we will have some time for questions and answers at the end. So keep that in mind. Again, if you have case-specific questions, it's best to just reach out to CILA directly for technical assistance regarding those. And this training is being recorded. So if you want to access it later on, we will post it to the CILA's website in about 1 to 2 weeks. So check back there. This course has been approved for 1.5 hours of Texas CLE credit. And at the end of the training, we will provide a survey for feedback as well as a survey for CLE. And there you can request for CILA to either report your CLE credit to the Texas State Bar, or if you need a letter of attendance if you're practicing outside of Texas, or if you're a DOJ accredited representative, and still fill out that CLE survey to get that letter. And again, we'll also give the survey for feedback. We take feedback to heart, so please fill that out. So we are very grateful to have our panel with us today, and I'm very happy to be able to introduce them. Our speakers are Judge Jenny Giambastiani, Judge Carol King, and Judge Christy Ann Padron. Judge Jenny Giambastiani served as an immigration judge for the Chicago Immigration Court from 2002 to 2019. She presided over the detained, non-detained family, and unaccompanied children's dockets during her judicial career. In 2010, she received an A-list Special Recognition Award from the Chicago chapter for her efforts to expand and improve pro bono representation before the immigration court, particularly for detained children. Between 1987 and 2002, she served in multiple capacities with the Immigration and Naturalization Service, INS, in Chicago. And at present, she is of counsel with a law firm in Chicago, Illinois. Judge Carol King served as an immigration judge from 1995 to 2017 in San Francisco and was a temporary Board of Immigration Appeals member for 6 months between 2010 and 2011. She previously practiced immigration law and has taught immigration law. Judge King is currently a guest faculty member at the Stanford University Law School Trial Advocacy Program. She also works as a removal defense strategist, advising attorneys and assisting with research and writing related to complex removal defense issues, as well as teaching trial advocacy for NEDA. She is an active member of the Roundtable of Former Immigration Judges and regularly presents and trains on a myriad of immigration law topics. Judge Christy Ann Padron was appointed as an immigration judge and began hearing cases in March 2022. Judge Padron earned a Bachelor of Arts in 2007 from Harvard University and a JD in 2011 from the Boston University School of Law. Prior to serving on the bench, she was a managing attorney from 2017 to 2022 with the Catholic Legal Services in Miami. And prior to that, a supervising attorney and staff attorney there. From 2012 to 2014, she was an associate attorney with a law firm in Florida. And from 2011 to 2012, served as a judicial law clerk for the Superior Court of Connecticut in New Haven. We're so grateful for your time, for being with us, and for sharing your experience. So thank you so much to our panel. Okay, fantastic. And so now we can see our panelists here today, and we're going to go ahead and jump into some of our questions. Okay, and so we know we have a lot of people on the call from a lot of different walks and also roles working with unaccompanied children. So we have some pro bono attorneys, some that are interested in getting involved, pro bono coordinators, staff attorneys. So thank you all for your efforts and work, and thank you all for being involved. And as we jump into questions, we're going to first start talking about just immigration court practice and procedure more generally. And considering if there was somebody new to immigration law, what would you recommend that they do to get acquainted with immigration court and procedure before entering court? And Judge Ambassiani, maybe you could get us started on this question.
Sure, happily. Thank you for inviting me to participate in this, and thanks to all of the people who registered for this. Pro bono representation is something that the court desperately needs. So hopefully we all can encourage you to take on some cases after today's presentation. So in my experience as an immigration judge, I think that the initial shock for attorneys who had never appeared before the immigration court was, let's just say, the environment. I saw one of two extremes from people who engaged in court practice, but not before the immigration court. The practitioners who would regularly appear in district court came in with very formal expectations. Attorneys who practiced more in, say, like county courts came in with a surprise as to how much more formal the immigration court is. Small example, district court proceedings, the attorneys came in prepared at the very first master calendar hearing to give lengthy opening statements. That doesn't happen at a master calendar hearing. So it is more of a quick docket at a master calendar, trying to move through, get to the meat of the matter. Attorneys with more experience in county court thought that they could approach and talk to the trial attorney for the government, reach some kind of agreement as to how the case would proceed, only to be shooed away or given the hand because that attorney is handling probably like 50 cases that morning and doesn't have time. So it would be so helpful to observe master calendar hearings, detained hearings, merits hearings with several different judges before embarking on your own representation, so that at least those initial jitters and unfamiliarity issues are taken care of. The court allows this. There are some privacy concerns. Obviously, asylum hearings are considered closed, but with the permission of the parties, you could be allowed to observe. Other differences, for example, from what inexperienced attorneys for immigration court might notice, is that the federal rules of evidence do not apply. There is no discovery in immigration proceedings. Evidence is typically admitted as long as it is fair and probative. The judge typically will deem the documents you wish to submit as admissible unless they're highly prejudicial or irrelevant to the proceeding, and then say that they are assigning whatever weight they deem appropriate to your evidence. You'll find that the trial attorney often embarks on cross-examination. It's kind of a fishing expedition. I remember that as my days as a trial attorney, because there is no discovery. You just hope that you get the information you're hoping to get. You know, like the rule that you got in law school of don't ask the question you don't know the answer to, you could throw that out the window in immigration court. So I would just say that the biggest help that you can do as an attorney considering taking on a pro bono case is to observe, get to know the parties, get to know the judge's preference, have some mentor, and get connected with local groups so that they will help you through these proceedings.
Wow, fantastic. That's great advice. Judge Padron, Judge King, anything you'd like to add to that?
I would just say although the federal rules of evidence is not binding in immigration court, the whole purpose of those rules is to make sure evidence is probative and fundamentally fair, which is our purpose. So it really is helpful to know the FRE. It is really helpful in terms of making arguments about how much weight to give evidence, whether certain evidence should be excluded and everything. You know, I went through my whole immigration career thinking I didn't need to know the FRE, but I'm actually much more convinced now that it's very helpful to know that it helps you argue on your feet the fundamental fairness of evidence.
Yeah, I know I'd add that people can object and people can litigate these issues in immigration court, even though it seems informal and doesn't happen as often. Sometimes I'm kind of looking, I'm like, no one's objecting to this, and you should definitely hold everyone to their burden and make sure that everyone's following, making sure that it's fair for everyone.
Great. And maybe Judge Padron, you can help us with this next question. So if somebody is new, what are some key sources to research and to learn about immigration court and procedure?
Well, thank you. And I'm so honored to be joining these former judges who have so much more experience, and I've already learned things just preparing for the panel. So I appreciate everyone's time. But I think to learn, when you first get started, you go to the basics, go to the statutes, regulations. The thing about immigration law is we have sources of law kind of coming from everywhere. We have the statutes, regulations, there's policy memos. Now those aren't binding, but they may give you some guidance. Sometimes we're telling people to go look at visa bulletins. So as a pro bono, it can kind of get overwhelming. And I would say, start with the basics. And if you're taking a case from a local nonprofit, they usually will help guide you in the right direction for where you need to start so you don't get overwhelmed. But if you're in court, you need to know and be going by the immigration court practice manual. You have to know what the rules of the court are. If you have a question, a procedural question about your judge, and you need to know, either ask around, join the American Immigration Lawyers Association or get resources from them, know your judge, or call the court and ask the judge's clerk if you have confusion, or if you're just confused about procedures, or just not the law, but just how things function. In terms of the observing, if you can't observe in person, there's also the model hearing programs that are being offered now more frequently at different courts, and there's recordings online, so you can just get an idea of what an immigration court proceeding should look like. And I think the link will be shared with everyone, the icore.eoir.justice.gov. And then National Immigration Justice Center, they have a ton of resources that are great for pro bono. And I used to be a pro bono coordinator, and sometimes I would use those to kind of help our pro bono. If we didn't have materials ourselves at Catholic Charities in Miami, we would share other resources. So yeah, and then ask. I think that's the most important thing. If you don't understand, it's better to ask than to guess or assume and get into trouble that way.
Great, thank you. Anything else to add? Okay. And so also, we touched on this some, but if somebody is new to immigration court, maybe their area is focused on a different area of law, could you give us more information regarding, what's most surprising about entering immigration court? What's different?
I think Judge Shambastiani addressed that somewhat before. The rules are somewhat different. You have to know the immigration court practice manual. It's going to differ from other courts that you've been in. It's always a little bit surprising to have sort of a less formal, I think it's less formal. Again, I practiced in federal court, so maybe if you're in state court, it's not so much less formal, but that doesn't mean you don't have to be prepared. And I think that's the primary thing that people need to remember. You may not, your trial attorney or ACC may not be constrained by that. Don't ask a question you don't know the answer to, but you shouldn't be asking questions you don't know the answer to, because you should be preparing your case and you should know your case inside and out. And you should have your client really prepared. And, you're still needing to convince the judge on those issues on which you have the burden of proof, which is most everything in immigration court, because very rarely are we contesting removability. It's usually you presenting an application for relief or more than one application for relief, and you have the burden on that. So you really do have to be very, very prepared. And I encourage a very high level of professionalism in immigration court. It's not just a forms practice, and it's not just a quick and dirty kind of situation. And I think that's surprising for some people.
Thank you. And Judge King, maybe you could tell us too, how did you view your role as an immigration judge when in the courtroom?
So I think my primary job, and the thing that I hope I got really good at over the years, was listening, to active listening, being able to hear the story that somebody was telling about their life, and being able to give space for that in the courtroom, and a space that felt safe, was respectful to all the parties, where somebody could talk about things that might be traumatic, that might be distressing, that might be very difficult to talk about. So my primary job was to provide that safe space for someone to tell their story, to control the courtroom to the extent that I was providing a space that's respectful for all parties, everybody who's there. I didn't expect more respect for my position than anybody else in the courtroom, but I did expect everybody to be treated with respect. And then to come to a conclusion based on what I'd heard that takes into account the facts of that particular case and applies the law to those facts and comports with due process. So that's a very hard thing to do when you're under pressure to complete cases quickly. There's always a balance to be hit between making sure that due process is always protected, but also moving the cases along efficiently. And so that was what I strove for as an immigration judge.
I do believe that being entrusted with being the fact finder and decision maker, we have an obligation as judges to be as familiar with the record backwards and forwards. We owe respect to both sides. You have to respect the government's position and submissions as well as that of the respondent. On a more practical level, I kind of viewed myself as almost like the director of a symphony, because you have so many different things happening in court that you have to make sure doesn't somehow negatively impact the record. You have to protect the record. So is your interpreter understanding what's going on? Is the interpreter connecting with the witness? Does the interpreter need a break? What is happening in the gallery? Is someone being disruptive, possibly dangerous? Is my tape recorder or the recording not working? I can't tell you the horror that is when you see that it stopped recording and you have to start from scratch again. So there's a lot, and at the same time, taking notes, listening, referring to the record, making rulings on objections. So it's a lot of multitasking for a judge. And knowing the record before you go into that hearing really helps you perform all those roles well.
Great, thank you so much. It's so wonderful to hear just from your perspective on these issues. I think a lot of times when you're the attorney, you're wondering, to get that fuller picture of what the judge is doing. And maybe for this question, we'll maybe all three of you could respond, but maybe Judge Giamatti will start with you. And so that would be, what would be your top 3 recommendations for practitioners to do to be persuasive? And if you want to include what they shouldn't do too, that's fine as well.
Clearly, we're going to just be the broken record. Preparedness. It's just so key. And it helps the case move along. I know pro bono attorneys are pressed for time. They don't want a case lingering for years and years. If you could at least start at the master calendar hearing, knowing the posture of the case, knowing what's been done, what needs to be done, have pleadings been taken or not, that really, really helps. Knowing the court rules, the procedures, knowing policy requirements, knowing your client. I can't tell you how many times people come into court never having met with their client, saying, well, I'm not sure, I still need to meet with him or her. So preparedness both with the court proceedings and with your client. You have, not many people realize this, you can make a request to the court to review the record and listen to the tape so that you can understand if the judge had issued any rulings for the submission of evidence for the next hearing where you're going to be stepping in and representing. How many continuances have already been granted? Are you going to come in and ask for a 6-month continuance when the judge said this is your last continuance? So I think that that's key. Another pointer would be flexibility. You can come in and ask for a specific. Attorneys would come in and ask for a specific date. Judge, we're ready to proceed. We want Thursday, June 1st at 3 o'clock. Well, that's not going to happen. That's really, so some flexibility, understanding the pressures and time constraints that the judge is under as well. And then civility. This is one of the please don't items I have. Yes, as a pro bono attorney, you are doing fantastic work, things that all judges should appreciate, but we do expect common courtesy. Don't hiss at the trial attorney. Don't be dismissive when objections are made by the government's attorney. If you don't, and this happened to me with a pro bono attorney, if unfortunately you don't get a decision that you like, don't stand up and say, you're going to be reversed faster than I can say the word appeal and then storm out of the courtroom. It is a legal proceeding. And so just be respectful. I could go on and on.
Well, and then also respect for your client. And I think that's one of the things that always bothered me the most is when people don't treat their clients respectfully. And it happens. People, I don't know, lawyers get to feeling like if their client makes some sort of mistake, it's going to reflect on them. So they start getting snarky to their client on the record while they're testifying or whatever. And don't rely on your client for preparation. If I ask you, do you have a medical exam and an adjustment of status case, and you turn to your client and say, did you get a medical exam? You're not doing your job, right? So make sure that you're not asking your client to do your job. And then don't rely solely on discretion. Or in other words, one of my biggest pet peeves is when an attorney comes in trying to pull on my heartstrings. I do have heartstrings. They're fairly flexible. They can be pulled on, but not as your initial, whatever, at bat. Okay. Your initial at bat should be the statutory requirements that you have the burden on, because we don't even get to discretion until you establish those. So make sure that you're not just coming in, and we had an attorney in San Francisco who used to bring in a severely disabled child and, carry the child in instead of letting the child come in on his or her wheelchair and plop them down in the front row, and then never did any preparation for the case. Just thought that somehow that was going to be enough because the attorney was being lazy. So, that is not an appropriate way to prepare a case.
Kind of jumping off of that was one of my things, is to know your case and know what you're trying to prove and know the elements of what you're trying to prove, because that's what we're looking at. So all the, unfortunately, sometimes irrelevant stuff will just distract, and maybe DHS will start objecting and we'll get away from the actual what needs to be proven, and past persecution or the hardship in your case. Just focus on what the judge needs to know and be able to grant. Discretion, yeah, exactly. Discretion is the last thing we can think of, and we think about it, but we can't do it if none of the elements are met. We can't just grant based on purely discretion. I would say in part of preparation, one of the things I would add is to always talk to the trial attorney ahead, or the ACC ahead of time. I usually, if I come in and I see that they have not spoken, or the respondents counsel just got there at right on the dot when I'm starting, I'll walk out for 5 minutes and be like, please talk about this. Because if we agree on every issue, if everyone in the room sees that nexus is the biggest issue that needs to be developed on the record, it's just simplifying the matter before the court. And you need to talk to your opposing counsel, because if they're not going to be opposing you on all those elements, you just need to develop and not re-traumatize your client about every terrible thing that's ever happened to them. Just focus on what DHS is focused on. And then again, prepare your client and know what their choices are. If they're offered PD, do they want that? Is that something that they are interested in? You should know these options and what the potential outcomes at the hearing are with your client before, so you're not caught off guard and the client's not caught off guard. And so that their testimony doesn't surprise you. Like you said, if you're developing your case and the testimony goes off track because you got caught off guard, that's because you didn't prepare, or possibly, maybe, there's always surprises, but as pro bono counsel, just taking the time to know your client and know your case ahead of time, it makes the world of difference. And it makes a world of difference for us doing our job, because we have a duty, at least in the Fourth Circuit, we have a duty to develop the record. And we have to make sure that we explored the elements and understand the case before we can make a decision. So I think we all appreciate following those guidelines that everyone said. Thank you.
Great, thank you so much. Now just turning over to something that some people might be wondering, just judicial expectations for pro bono attorneys. And so, as an IJ, what are your expectations for pro bono attorneys? Are your expectations the same as they would be for any other attorney, or something different?
So I have to say that my expectations are pretty much the same for pro bono counsel as they are for any other attorney. I think that immigration judges should be taking into account resource limitations and scheduling, especially limitations. For instance, we had several law school clinics that would represent people. They couldn't represent people in the summer. They didn't have, their schedule was restricted. And so I always tried to accommodate that on my calendar. But you can imagine that it would be inappropriate for me as an immigration judge to say, oh, well, you don't really have to prepare as much because I know you're pro bono and your resources are limited. And where does that leave your client? Your clients deserve the same level of representation as somebody who has lots of money and can afford to hire a private attorney. So there are resources out there for free or for low cost. For instance, expert witness declarations and that sort of thing. And maybe a judge will be accommodating in terms of allowing an expert to appear telephonically or not to appear and to take into account their declaration. There are a lot of ways around the resources issues. A really good resource is the CGRS out of Hastings Law School. They have a lot of expert opinions relating to gender and other refugee issues. And they're happy to share those. They want you to help them keep track of how cases are being decided. So they want you to report back on how your case eventually ends up so that they can keep statistics and that sort of thing. But they're very, very generous with their time and their research. And there are others, and there are professors at universities that are willing to testify by telephone and that sort of thing. So explore what the resources are, but don't expect that you don't have to be as prepared because you're pro bono counsel, and everybody should understand your resource limitations because your clients deserve better than that.
And what have you seen from pro bono attorneys that has worked well? Maybe Judge Giambastiani, you can answer that one.
Again, I go back to I'm not muted, no. I go back to the preparation and having observed beforehand. That really helps. But since I already said that, let's move on to other things. The pro bono attorneys might have a tendency to believe that more is more. Now, keeping in mind that judges have limited time to review all of the filings. They do, but if you do like gang activity in El Salvador, a Google search and hit print and then submit to the court 4 boxes of background information, it's not likely that the judge is going to be able to review all of those. So be selective. What I really liked was when attorneys would submit a country report, some piece of evidence, and then provide highlights of the sections that were particularly pertinent to that case. And in the table of contents, just a brief summary as to the relevance of that document, referring to the specific pages. That was immensely helpful. A pre-hearing statement so that you know exactly what the particular social group, if it's an asylum case, you're articulating may be. That helps the judge when doing an oral decision on the record. You have the burden of defining the particular social group. If you're applying for asylum under that basis, it is not up to the judge to try to figure out what that social group is at the end of testimony and the record being closed. So help the judge, guide the judge, create that roadmap for the judge in your submissions. Don't overfile, as I stated already. And it's just really helpful to be familiar with the parties, the judge's clerk, the judge's preferences, the court rules, the procedures manual, just so that you avoid any unnecessary delays and objections, maybe from the government.
Great.
Just might add one perspective from the Board of Immigration Appeals perspective, which is that judges love highlighting in background evidence especially, and the board hates it. They feel like they're not getting the pure document, and the highlighting may have influenced the judge and blah, blah, blah. So they don't like it at all. So I would suggest, as a little trick, is submit a clean copy for the record, and then come into court with a highlighted copy for each of the parties. Make sure that DHS gets anything that you hand the judge, so they know, what's been highlighted, and they can highlight something else that they think is important or whatever. But, have that be a separate thing that the judge can look at and refer to as they're reviewing the evidence, but it doesn't go into the final record.
That's a great tip, Judge King. I wasn't aware of that.
I wasn't either until I went and served on the board for 6 months. I had no idea.
That's a fantastic tip. We actually did get a question about whether y'all have any tips for lawyers filing pre-hearing briefs. So we heard a little bit about that, but just wanted to mention that too, to see if there's anything else that y'all would like to add.
I didn't used to think this, but I now think, with all the time constraints in immigration court, that a pre-hearing brief is necessary in pretty much every single case, unless it's really a simple adjustment or something like that. But I think that with judges strapped for time, some judges won't allow a closing argument, or they want you to keep your closing argument to 2 minutes or 5 minutes or whatever, that you have to have your arguments in writing in the record ahead of time. And then you can refer to your pre-hearing brief. You can say, my argument is there, Your Honor. I just need 2 minutes to address some issues that came up at the hearing. And then stick to that 2 minutes, respect the judge's time. I think it's very, very, very helpful to have a brief in every case now.
If I may interject, I hear that some courts, some judges are now making that a requirement in all filings.
Yeah, I think part of the why can't I think of the word? These new policies where we're trying to avoid masters and go straight into merits, I think that's a very helpful way to establish your case. And I think it goes back to preparation. If you've prepared and briefed your case, that means you already know why you qualify in every way. So you're coming in more organized, and your direct is going to be cleaner too. So I think all around, it just helps everyone in the room be on the same page, understand why you're there. So I agree. I didn't always tell everyone to do them when we had 120 cases. Some people, when everyone was overwhelmed, we did. And now I would say it should be done for every single case when you're going for a merit. So yes.
Great, thank you so much. And so now we've talked about maybe what has worked well. What have you seen from pro bono attorneys that has not worked so well?
Well, I think one thing that's a problem with pro bono, and this is from my past experience and from current experience, is that sometimes cases have been delayed. The last few years have been confusing and hard, and then we see cases turn into hot potatoes. And you see that the firm passes them along to a few different counsel or associates, or just withdraws after 3 years. And then this respondent is now pro se with a huge filing, and the chances that now they're 21 or something, if they were an unaccompanied child and they took the case when they were young. So I think that for pro bono coordinators and for pro bono attorneys, just be really aware of what the process can be like, that not every case is going to be solved in 6 months, and that cases may sometimes go on for a long time. Or communicate with the court if it's something's going to happen that you're not going to be able to continue with the case, and see if the case can get advanced. Or don't just be a victim of continuances or or priorities in the court. So I would say that's some were losing representation after someone took them on. Some judges really dislike if you mention that you're taking the case pro bono, like you're telling the judge basically that they shouldn't expect you to do as good of a job. It doesn't bother me. It gives me context for scheduling, but some judges really don't like it. So definitely, I think the biggest thing is just to know your judge ahead of the hearing. Make sure you talk to other practitioners before you go in blind. And then I think we all agree on this, just uncivility, like unprofessional conduct. Wear a suit to your hearing. Don't just respect the court and respect your client, because your client, even if they're not paying you, they're trusting you with their whole case. There's no reason that they deserve someone that's just not professional. You're their attorney. You still have your ethical obligations, regardless of whether they're paying you or if a nonprofit is hosting your case. And then with the excessive or repetitive filings, like I think we've already talked about this a lot, just be selective in what you submit and make sure what you submit is relevant and helpful. Every single thing you have should be proving one of the elements or the unable or unwilling for country conditions. And I disagree, but maybe I will change my mind in a few years. I know that the BI has a different perspective, but I do think it's good to pull out at least what you want the judge to focus on when they're making their decision, because we don't have a lot of turnaround time for the decisions.
If I can add something, we've been speaking about how the attorney should be prepared for court appearing before the judge. Prepare your clients. A big no-no is focusing so much on your filings and presenting your case that you didn't prepare your client for what's going to happen in court. They might freeze. You might not have identified the correct language. I had that happen where nobody thought that this person who was assigned a Spanish interpreter really speaks an indigenous dialect and has very limited Spanish speaking abilities. Them not even knowing that they were appearing for their final hearing and all of a sudden saying, what, you just ruled on my case? So don't forget your client is really important in your preparation as well. And Judge Padron spoke about wearing a suit. Tell your client to dress appropriately. Shorts, a tank top, and flip-flops don't work. I don't care that it's 100 degrees in Chicago in July, so don't forget that aspect of your hearing.
Yeah, and just to add about the your exhibit list, I really agree that having an expanded exhibit list that brings out important aspects of each document is really, really helpful. Sometimes the judge will only have time to review that before the hearing. We get backed up too. And that can really help the judge know what's coming down the pipe. It's very helpful if you do that document, that table of contents, if you will, by issue. Because if you do that and you have your documents arranged by which issue they prove, you've told the judge that you can prove each and every one of those elements, and this is what's going to do it. And that's very, very helpful in the judge in outlining our decisions and knowing what's going to happen at the hearing, who's going to talk about what, and all of that. What documents fill in the blanks in between the testimony. Very, very helpful, and it helps you stay organized.
And this is just silly, but don't bury the lead. Don't bury the lead. If you have like death certificates and they're 2 pages interpreted, it's or translated into English, but then you bury under 400 pages of documents, the judge, it might just get a little bit lost, or it might just not be the focus. So like Judge King said, just you're helping yourself by being organized and presenting it by the issues to show you can prove the elements.
These are some really great tips. Thank you all. Moving to a memo that came out in November 2021, and this is encouraging and facilitating pro bono legal services memo. And what can you say about this?
Well, I think that it's just capturing the best practices that should have been in place in a lot of places, but it's giving us all some guide. It's all giving all the judges some great guidance and suggestions. And I think it's great for our pro bonos to be aware of it before you go in, because there may be things that the judge, you can point to it to say, hey, judge, you should be flexible on letting me appear via WebEx. And you could include that in your motion, maybe, because maybe some judges really don't like it, but they may reconsider their position if you're a pro bono coming from 4 hours away. And I think, I think it's a step in the right, it's a great step. And I'm glad we have this to rely on when we're organizing our court. But I don't, a lot of these practices were already in place in different judges. So I think it's just more of an organized way of just having it all in one place to refer to.
Great. And are you able to expand a little bit just in terms of other options it gives judges?
I think for rescheduling, I think for prioritizing pro bono cases, for being more flexible and calling pro bonos first when you have a large master calendar where people might be there for 2 hours. One thing that I want to get working on here in our new court is having an ACIJ led pro bono committee for each court, and just expanding the conversation with local pro bono providers so the court can help facilitate whichever way to place more pro bono representation. Honestly, in my experience, starting from masters, just having pro bono representation will just change the whole nature of a case. Instead of seeing a child that's come 3 times and never found an attorney and aged out of special immigrant juvenile status, they're coming, the masters just change drastically when there's pro bono representation, and we're solving problems, cases are getting dismissed, people are getting relief at the asylum office. I mean, it makes such an incredible difference. So I think however we can use this to increase representation rates, it's kind of weird. It will vary by court, but I think it just gives us a kind of more cemented way of looking at pro bono. And especially for child respondents, there is this memo, and there's another memo that I wanted to point to for later, which is a December 20th, 2017 memo that gives more detail about basic principles and help with juvenile dockets. So I think between the two, we're getting a lot of different options to make us more flexible and improve the representation.
I just really want to encourage everybody in your own locality where you practice to coordinate with the court administrator, with DHS, through CILA, through whatever organizations, through a consortium of pro bonos in your area or whatever, to develop programs within the immigration court if you don't already have them for pro bono representation. We did this in San Francisco in the late 1980s, early 1990s, where DHS representatives, CILA representatives, representatives from the court all got together and created a pro bono master calendar program that's administered by the Bar Association of San Francisco. And it's been going ever since. And it's just what Judge Padron was saying. It's extremely helpful. And it means people are getting oriented before their first master. It means there's somebody there to help them through that first master. It makes the masters go far more efficiently. So the court benefits as well. It makes it easier on DHS because they're not getting bogged down with a million questions from unrepresented people. And then the Bar Association can help refer those people out to more permanent representation. So whether it's master calendar, whether it's other types of representation, please be proactive in your community and bring people together to try to make better pro bono programs for folks.
Yeah, you don't have to reinvent the wheel. If you're a pro bono coordinator, like Chicago, San Francisco, New York, have really well-established pro bono programs, and reach out to people in those jurisdictions to see how they did it, to get ideas I think that it would be very helpful and expedient to getting something up and running where there isn't such a thing in your court. And also I want to stress that when the chief judge issues a policy memo, I'm sorry, it might not be binding, but it's issued with the expectation that you're going to follow it to the extent possible. So if you run into a judge who isn't accommodating as per that memo, you have every right to raise it to the liaison judge, the pro bono liaison judge of that court, or to the assistant chief immigration judge, because like I said, it is expected that you will follow that as an immigration judge. Don't be afraid to, follow up on that.
One thing I'll say is that it's kind of encouraging the good behavior for the immigration, not good behavior. It's encouraging us as judges to do outreach and try to encourage representation, right? One of the things is suggesting handing out the pro bono list. There's also these self-help centers. We don't have that set up, but all the materials are there. And I was actually printing the self-help materials and handing them out at masters and handing out the pro bono list. I mean, that's not necessarily what every judge is doing, but I think this is kind of codifying a way that the judges should be more proactive in trying to encourage pro bono. So it's hard because if they're not pro bono, if you're not in court and you're not seeing it, how are unrepresented people going to be asking for these policies to be enforced?
Right.
So just, but that's where it comes in, where I think the community in general has to be looking at the greater picture of like how many people are unrepresented in the court and what's the need, and trying to bring it to the court's attention what we could do to make it better.
Well, we in Chicago had a lot of court observers who would be very quick to raise issues for things that they saw that they didn't like to our supervisors. So I don't know if you have that in your court, Judge Padron. And then I'm sorry, but with regards to the self-help materials, in Chicago, we were one of the first courts that we created a library of it, all displayed in English and in Spanish. And so people who walked into the waiting area after security, they saw all of that. And while they were waiting for their cases to be called, people would just pull the material, start reading it. And it was really great because it was out in the public. You didn't have to ask for it or, learn about it after the fact.
These are some fantastic ideas, and it's so great to get insights from what's going on around different courts in the country, because, frequently people just practice in one location and so they might not be able to see it for themselves. And so just sharing this information gives people ideas in terms of some additional advocacy efforts or ways to maybe implement some of these programs in your local courts, and even just taking it step by step. And if you're before one judge and need to remind them of the memo. So
Yep.
Thank you again for these points, just to share the information. One thing that's really important for everybody to realize, if you are new to working in children's immigration cases, is that while children have a right to counsel in immigration court, there are no appointed counsel for children. So with that, what need have y'all seen from the bench for attorneys and representation in children's cases specifically?
Anyone in particular, Laura? No.
Well, Judge Giambastiani, if you want to start us off, we'd appreciate it, just in terms of what you've seen.
Sure. I was one of the first judges to be assigned the detained children's docket in Chicago, where one judge would hear all of the children's cases, detained and non-detained. And that was something that was really helpful because the attorneys didn't have to keep coming back. The few attorneys who represented them didn't have to keep coming back day after day after day. It was more of a consolidated docket. And you got to know the judge and you got to know the preferences of that judge. So that really was helpful for the juvie docket, as I like to call it. One thing that is surprising, I think, to practitioners that have dealt with children's cases, maybe in state court, is that there is no guardian ad litem. So you have an attorney representing a child whose obligation is to represent the wishes of that child, but may not necessarily be the best interests of that child. And you walk a fine line. I've had attorneys coming in requesting voluntary departure for a child where I sensed that that wasn't the best interest of the child. So without the guardian ad litem, the judge almost becomes the guardian ad litem. You have to use your sense as to what is best. And like in that particular case, I was lucky. This is a whole different story, but the Chicago court has the child advocate program, which is almost likened to a guardian ad litem program. But I had to deny the child's request for voluntary departure, and I assigned the child advocate to the case. And it was just that the kid didn't want to be in the facility anymore. He said to the child advocate, I just would rather go home and be killed than to continue being in this facility. Their expectations coming across the border are they're going to work and send money back home, or I'm going to, join my relative. I'm going to go to school, whatever it may be. And then all of a sudden they're in a child's facility that they just feel that all their dreams have been dashed. So the child advocate program has really, really helped with that. And I understand that they're expanding to almost all of the courts. Now I've lost track of the question.
Well, I can add something that one of the things that judges are allowed to do pursuant to the memo that we were talking about is to make referrals in juvenile cases. And so that's a really important thing. We used to make referrals way back when I started being a judge. I mean, it was a very informal thing. I'd have a kid and I'd call up, legal services for children and say, hey, this kid's been to 3 master calendars. They don't have representation. Their mom's very young. She doesn't seem capable of finding representation. Would you take a look at it? And then they usually would take a look at it and often come in and represent the child. And then I think during the Trump administration, that became prohibited. It was one of many things that was seen as bias towards immigrants. And we weren't allowed to, I didn't work under Trump for very long, like 21 days. That was it. Then I retired. But the judges weren't allowed to make referrals. And that, I think, was a really bad thing, particularly in juvenile cases. So that's something that if there is a pro bono program, if you're in that program, if you work for that program, or even if you don't work for that program, that's another thing to coordinate with the court administrator to make sure the judges know about the program and know that they are allowed to and encouraged to make referrals.
Fantastic. And I don't know, Judge Padron, if you have anything else to add on this question, just in terms of what you've seen for the need for representation in children's cases specifically.
Well, I just had my master's this afternoon and had 10 unrepresented UACs and 4 that came with attorneys, and the difference is huge. And this was a first hearing, but some of them had NTAs from 2018 with no time or date and had never come to court because their court got continued and continued, and the NTA was filed 2 years later. So it's just so much confusion surrounding those cases, and obviously not all of them appeared because I don't know how they could have. So I do think that, that's the first case, but I just think the need for pro bono representation is so big in every court in the country. Our court, I have the juvenile docket. I have the biggest docket by at least double of everyone else, all the other judges in our court. There's just more juvenile cases than anything being filed. And they have so many forms of relief outside of court that are basically impossible to pursue without an attorney. An adult, I have adult per se dockets on Thursday, and I can walk them through trying to get them, and some of them do file their own asylum application or fill it out, get help. But you cannot do SIJS without an attorney, and you will lose that opportunity. And those are the kids that are most vulnerable because they're not with a parent, they're staying with a cousin or someone, and those are the ones I'm most worried are the risk of trafficking. And with an attorney, you can change their life so drastically, and so, and it just makes such a huge difference. So the need is ongoing. I know that there was a big surge, and every year I feel like the pro bonos we're trying to recruit people because there's a new need, and just the need's ongoing. It doesn't change. So there's a need for quality and dedicated pro bono representation that will stick with the case, and even when there's ups and downs and changes in administration and changes in priority cases, and stick with them.
One thing that I did on my detained children's docket, because attorneys were reluctant to enter appearances, because if the child would be released after the master calendar hearing, they'd be on the record as the attorney for that case, even though it might get venued after release to say Houston, Dallas, whatever. So we did a meeting with the National Immigrant Justice Center, who was interested in representing these children at their master calendar hearings, but didn't want to, and they wanted to appear as friends of the court because they didn't want to be on the hook representing these children after they got venued out of the Chicago court. In order to get pleadings, because the judge, even if the child is a baby, I need to get pleadings on the notice to appear. I need to identify relief. I allowed them to enter their appearance. They could enter pleadings if they were ready to do so, identify relief, and then I would allow them to withdraw at the end of the hearing. It creates an immense amount of work for your clerk because you're entering the appearance and then entering the withdrawal, but they then decided that they could take all of the kids. They could represent all of the kids at the master calendars. So you could be creative. You could try to come up with ideas, propose them maybe through the pro bono liaison committee at each court now that is required. There's workarounds.
Thank you so much. And knowing that there is a mix on the call, some pro bono attorneys as well as some pro bono coordinators working with several pro bono attorneys, could you provide any information to the pro bono coordinators at nonprofits in terms of what guidance they should give to pro bono attorneys on how to form a good working relationship with a judge?
So generally, I think immigration judge, you hopefully have gotten a feeling from this call that generally immigration judges really appreciate pro bono representation and pro bono attorneys. If you're new, it's hard to get to know an IJ if you've never been before them. One thing is talk to colleagues. Pro bono coordinators should start keeping feedback from all of their pro bono attorneys about various judges and what their preferences are and that sort of thing, so they can pass that information along to attorneys that are going to appear in front of that judge. But also, do not be afraid to ask questions. As an immigration judge, I would much rather have somebody ask me at a master calendar, how do you prefer to take documentation? Do you want me to send it in packets every time I get something, or do you want me to wait until 15 days before the hearing and send it all in at once? And literally, judges have different preferences on things like that. Some judges review the case over and over leading up to the hearing, and they'd like to see the documents as they come in so they don't have a big overwhelming amount. I often didn't get to look at the file until a couple nights before the hearing, and I wanted to see everything all at once in, one big packet if I could, so it just varies by judge. So don't be afraid to ask questions and don't bluff your way through something that you don't know. It's perfectly okay not to know. Pro bono attorneys should have supervision or mentorship from the pro bono organization that they do the work for. It should be built into the program. That's something that, for instance, that we have in San Francisco, the Lawyers Committee used to be called the Lawyers Committee for Civil Rights. Now it's I'm forgetting, the Lawyers Committee for Human Rights maybe, but it's changed names, but they have an asylum program. It's been going again since the early 80s. And they match up a pro bono counsel, usually from a big law firm, somebody who needs to do pro bono for their firm or whatever, with an experienced immigration attorney that guides them and mentors them through the case. So those are some of the very best cases, because people come in prepared to really put a lot of work into a case. So they know what they're doing. They appear in federal court all the time. They tend to be more formal and more prepared, but they don't know immigration law. So they have a mentor that helps them through that aspect of it, and lets them know what's expected for the preparation of that case. So I would say to pro bono coordinators to the extent that you can, match people up with experienced immigration counsel that might not have the time to do extra pro bono work on their own, but they might have time to just mentor a new attorney or someone who's not used to doing immigration law, that isn't their major area of practice.
I would like to encourage the pro bono coordinators from the large law firms to go with one of the attorneys from the firm that is taking on a pro bono case, so that the coordinator and the attorney taking the case are familiar with what's being expected and how the immigration court runs. Here in Chicago, the pro bono coordinators at the large firms usually work hand in hand with the National Immigrant Justice Center. They get the training through them, but some of these firms in other cities don't have something like the equivalent of the National Immigrant Justice Center. So it has to be a learning experience for the coordinator as well.
Great. And are attorneys able to co-chair a case in immigration court?
Sure.
It's in the memo. It's in the
memo.
policy memo.
Great. So that's one option as well to consider for pro bono attorneys. And then Judge Key, maybe you could answer this. What advice would you provide to pro bono attorneys regarding secondary trauma and self-care?
So this is kind of a pet project of mine, and I do presentations on secondary trauma and self-care. If any organization wants to do a Zoom training on that or whatever, feel free to email me. But it's really important to understand this work is hard. It's not easy, and it's not just because you have to be so prepared and everything. It's also because you're listening to stories of trauma. And as human beings, when we hear stories of trauma, we react. We have certain responses in our bodies and in our emotions to those stories of trauma. We may think that as lawyers, we're immune because we're tough and we're neutral and objective and smart and all that. But the reality is that there are certain things that the human body and soul react to. And hearing stories of trauma, we have a similar traumatic reaction to PTSD. It's not as intense as somebody who's been through an actual life or death situation. But it's still, over time, when you hear these stories over and over and over, you can get burnout and you can get compassion fatigue. It has a lot of different names, but it's essentially a secondary trauma reaction. It's really, really important to know what the signs of that are, to make sure that you have a self-care plan in place before you ever start experiencing those signs, that you care for yourself. It's part of the way that you prepare your cases. It's actually really important, because if you want to do this work for the long term, if you want to do it without getting burnt out, and you want to keep giving the best representation you can to your clients, you need to be prepared to take care of yourself in the process. It's just part of what you need to do. Make sure you're spending time with family. Make sure you're getting movement in your life, whether you're an athlete or whether you just like to get out and walk in nature or whatever. Make sure that you're using your body, you're spending time with friends, and you're eating healthy, and all of that is really, really important. And make sure that you have people to talk to about your experiences and what you're hearing, so that you can process the emotional. I think I said before, part of my job as an immigration judge was to hold space for someone to tell their story. Well, in that space that I'm holding, there's not room for my emotions, right? So I have to find a space outside of the courtroom to take care of my emotional responses to what I'm hearing. And you have to do that too as attorneys. If you have interpreters working in your office, if you have front desk staff who are doing intake, those people also are often very severely affected. And an organization can become dysfunctional if you don't take care of that, if you don't leave space for talking about it, for processing, and for self-care.
Wow, that's fantastic advice. Thank you so much for your work on that initiative, that pet project, but also for sharing here. We appreciate it. And we also want to talk some more just about judges' perspectives about children's cases in general. And some people on the call may be new to children's cases. So maybe we could just cover some really basic information about children's cases in immigration court. Whether they have children's dockets, if these are just for detained dockets or release dockets. Maybe Judge Padron, you could give us some insights and information on that.
Well, I think every court is dealing with it slightly differently. Like at my court right now in Sterling, we only have non-detained juveniles, but we do have them all separated. Like all juveniles are with one judge. We may need to have a second one, but right now, just with me in Miami, we had one judge that had the detained children, and that was as regularly scheduled. Everyone knew when it was. And then several other judges that were designated by the ACIJ that had that skill set had juvenile masters throughout the week. It really depends on where the jurisdiction is, what resources there are, or what is needed. Like here, all of Annandale handles all the detained kids for all of the Virginia area. But are there other questions we can talk about from what you're interested in knowing about the children's cases? The dockets generally, we have more in here. We have more detained in Annandale. When I was there was more representation on the detained docket, but I know what Judge Giambastani.
Jenny is okay.
I'm so sorry. What Jenny was saying was that they had more difficulty placing detained cases there because they were, so I think it really varies depending on the jurisdiction, what needs are going to be. And I saw one of the comments and one of the questions about just the capacity. We know that everyone's trying really hard to get funding and help for these populations. And we know that you all know the need, but it's any way that we can just make sure that potential volunteers know how important the need is. That's why we want to make sure it gets home. The dockets are just different because we take it a little bit of a slower pace. We try to ask, depending on the child's age, to try to be, sometimes I feel like I'm going so painfully slow for DHS, and they're not. We're just trying to make sure that the person leaves and understands to their level what they can understand, or if there's family there, that they understand what their next steps are and they don't leave confused. Leave with a change of address fill out, make sure they have change of address filled out, make sure. So I think that depending on the judge, and most courts are doing this, you're putting the juveniles with a judge that's going to be patient and try to tailor the docket to what's needed. Most of my merits hearings are not juveniles. Most of my merits hearings are juveniles UACs that have aged out and been referred back from the asylum office. So I don't know if the other judges had different experiences they like to share about the juvenile dockets.
So I handled the detained and non-detained children's docket. So I'd like to just focus my comments on the detained children's docket, especially under this administration and this chief judge. I quasi interviewed the judge that is handling these cases now in Chicago, and most children's presences are waived. So the attorney is appearing and the kids don't have to. What I would do is, before that was feasible, I would group the children into either the detention facility that they were being held at, so that whole group would be brought to court that date. Sometimes it was like a 7-hour drive, as opposed to making ORR go pick up one child in Indiana, one child in Wisconsin, 7 children in Chicago. So I would try to cater my docket to facilitate the appearance of these children without too much effort or difficulty for the attorneys and ORR. So yeah, ask for waivers of presence of the children. Another thing, before starting court, I would usually have the attorneys come in without the children, and I would specifically ask, are there any concerns for any of the children appearing today? Any special accommodations that I need to make? So like if one child was going to be testifying to, let's say, a sexual assault suffered on the way to the United States, and that girl did not want to testify in front of people or wouldn't open up, I would agree to close the courtroom or take that case first or hold that case to the end. I would clear the gallery, no observers. I'm sorry, this is now going to be a closed hearing. It's hard to guess. You as the attorney know far more than the judge does, and the judges are more than happy usually to accommodate these special concerns, but you have to communicate them. I had a couple where it was suspected that the smuggler was in court. So, clear the courtroom, don't have them sit in the gallery. Again, having a child-friendly courtroom helps. If having a little toy with them helps at the bench, at the table, that's fine. If they want to sit with mom, let them sit with mom. Let mom come up to the table and hold the child. The key is just flexibility, because after all, what are we trying to do? We're trying to go from point A to point B, and it's in everybody's best interest to do whatever it takes to get there.
These are some great points and tips, and I think it's an important question. If you are going to be representing a child for the first time in court, what advice would you give to the attorney to be able to help the child in that experience? So if there are any additional tips or points, just to provide some space for that.
Yeah, and in addition to the non-detained setting, I will waive presence for masters usually too, especially if they're in school. So if once they have representation, even not pro bono, I usually encourage them to waive. I ask DHS if they object to waiving presence, because some of the attorneys don't know to ask, and that you missed a whole day of school for a 10-minute hearing. So I think just if you ask, the judges usually are going to accommodate. Sometimes they don't think of it.
Yeah, in San Francisco, I had not specifically a juvenile docket, but I had a families with children docket. And so usually it was very, very young parents with little kids. So they were practically kids themselves anyway. And so I would have the children appear the first hearing, and then waive presence after that. I wanted the whole family there in the beginning because I wanted to make sure that the whole family was intact, that, there wasn't a kid missing or somebody hadn't run away or, and I think that kind of leads me into another point, which is we should all be watching out as judges, as ACCs, as attorneys, as pro bono coordinators, whatever. We should be looking out for human trafficking, signs of human trafficking with kids especially. And that can happen. And it's, that was part of the reason I wanted to make sure all the kids were present that first hearing. And I wanted to make sure they were lined up with their family members and they weren't sort of out on their own with somebody in the courtroom who looked to be maybe a smuggler and couldn't quite articulate their relationship, or, said, oh, I'm the uncle or something like that. So that was, a friend.
Yeah.
So
I just want to add one thing. I had a lot of detained children who were 17 years old, very mature and savvy. And I don't know how I feel about waiving the presence of everybody, which seems to be happening now, without at least that first appearance, because these kids 99% of the times are going to be released and they don't know that they're in proceedings. And so, especially depending on their age and maturity level, I would try and instill on them, this is a removal hearing. The government wants to remove you. I wasn't like that with the young kids, but kind of like to give them that stern talking to so that they knew they needed to report their address when they were released, that they had to appear at all hearings, that if they don't show up, they're going to be ordered deported. So that was the one reason that I really, really pushed for them to appear before me. Little kids, no, I mean, they're not going to be listening to you. A 4-year-old is not going to listen to anything you say. So
I think we just have to meet them where they are, right? We need to
exactly
alert to the situation. And
well put.
when I waive appearance, I do tell the teenagers, especially, that if they do not continue with their attorney, that they still have to come. If they're 14 and in 9th grade, I just want them to go to school. But if they're not in school, or if they lose their attorney, because you don't want them to get lost if the attorney has to withdraw. So I agree with you on that. I think that's a great point.
Well, great. This discussion has been fantastic, but we should move on to answer some questions that have come up. I want to make sure to be able to have some time to address those. One question in the Q&A is, are there resources available to the judges to encourage trauma-informed interactions with unaccompanied children?
Can I refer that attorney, I'm assuming, to possibly reaching out to the Young Center, YOUNG, Center for Children's Rights? They are the child advocates in the courts. They're the ones running the child advocacy program. And they started off in Chicago, and they've now expanded to most courts. Very amenable to questions. That's what I would suggest. Just look up the Young Center, reach out to them, and they'll probably give you some ideas and some help. And who knows, they might take the case and serve as child advocate.
And I don't know too if that question's getting to what trainings judges have, or what options advocates have in the courtroom to encourage child friendliness as well. I don't know if you could speak to those things as well.
I could talk a little bit about that. But as far as training goes, at least when I was there wasn't much training on either trauma-informed courtrooms or working specifically with children. When we started having what came to be known as the rocket docket, the unaccompanied minors and families with children, most of the unaccompanied minors were applying for asylum and going to the asylum office, and we were administratively closing those. But I had the families with children docket, and I had to develop best practices for dealing with kids in the courtroom because we literally didn't have them at that time. Now there's a memo, and there's at least some thought about it now, but it wasn't really there then. And so I talked to a friend was a juvenile court judge in the state courts, and she gave me a lot of really good information about, and this goes for adults or children really, but especially with children, I developed a program where I would meet everybody in the master calendar in another courtroom other than my own. I would take the ACC with me and the interpreter and my clerk, and I would introduce everybody. I didn't wear a robe in those master calendars. I, would show them the courtroom and say, this is where I'm going to sit. I'm up here because I have to run a tape recorder and record everything. But, and I would, explain what was going to happen and all of that. So I think that, there are things you can do for a merits hearing. You can ask the judge that, not to wear a robe, to have the hearing around a table rather than being, and again, it's the recording that's difficult with that because that machinery doesn't really move around. But, there are things that can be done that help make the courtroom a less frightening place and a more familiar place for kids. And a lot of it is just really, if you can take the children there and show them the courtroom, tell them where different people are going to be sitting, tell them what questions they'll be asked if they're old enough to testify. There's a lot you can do to just make kids familiar with the courtroom.
Great. We are running short on time. This has been a great discussion, but I just want to try to raise another question here, and then we might turn it over to closing. But there's a question regarding, that it's less common for attorneys to deny the charges and hold the government to its burden in immigration court rather than in criminal court, for example, where it's commonplace. And, they think sometimes attorneys are afraid of doing that as it might irritate the judge. That might be the perception. And they therefore concede when they shouldn't. And so what are your insights and thoughts on if this is appropriate and if there are instances in which you might be irritated if someone denies the charges and doesn't make any concessions?
I think it's a case-by-case thing. And the times I got irritated was, when attorneys did it in every single case or did it only in the cases where it was clear. I mean, you could just tell that they didn't have any relief because that's the time they would do that. You could tell they had a weak case, because they would deny allegations without really any basis. So but I do not think you should be afraid of doing it if there's a basis to do it. And I think in every single case, you should be exploring, how did that NTA get issued? What was the contact with the officers, the arresting officers, the Border Patrol, whoever? What was the situation? What kinds of documents were gathered or admissions were made that might not have been kosher because of the situation? And if you have a basis for it, absolutely, you should definitely deny the charges and contest removability.
I didn't approve of that as a general practice. There were some attorneys that would file, that would not enter pleadings and deny everything for every single case, only to then go to a hearing where you make a finding, let's say of removability, and that person had like a great form of relief. So that hearing could have been scheduled a year earlier and that person could be a lawful permanent resident. So by all means, know the record of deportable alien, the Form I-213, oftentimes is a good tell if you should be filing a motion to suppress or denying removability. But as a to do it in all cases, I guess I would say no.
I don't think any of us would say to do anything in all cases, right? Just know your case and what's appropriate. Read the room.
Yeah.
Well, maybe that's good advice to leave us off. And so thank you again very much to our panel, to everyone who's joined us today. I do want to just provide some brief information as we close out. As we've been talking about, there's a great need for pro bono representation in children's cases, and CILA does host a platform on our website called Pro Bono Matters for Children Facing Deportation. It almost acts like a bulletin board. Nonprofit organizations from across the country can post cases that currently need representation. Currently, 18 organizations post cases there. And so we welcome you to go to that website and express interest. And then that posting organization will follow up with you to give more information. We really have the goal at CILA to have more matches with pro bono attorneys to these cases so kids don't have to go to immigration court alone. So we really encourage you to check out the platform, express interest, share it with a friend, help us spread the word. And we have many resources to support you as well. So there's pro bono guide, resources on our website, our newsletters. I know there's information going on in the chat regarding those, so feel free to check those out and view the handouts there as well that consolidate several resources put out by CILA and the ABA Commission on Immigration, as well as information per jurisdiction where those cases are located on the platform. So with that, we're going to turn to the end of our webinar. Thank you again to our panelists. We appreciate your interest, your participation, your time, your work that you're doing. Thank you to everybody who's joined us today. At CILA, we do value your feedback, so please complete that feedback survey. It really informs how we put on trainings. Also, if you want CLE, fill that out too. If you're in Texas, we'll report the CLE to the Texas State Bar. If you're outside of Texas, still fill out the survey because we'll send you a letter that you can provide as a DOJ accredited representative or as an attorney out of state. Stay connected with CILA. We're here to support you, and thank you again for being with us. I hope you all have a great day.